Welcome to the Goal Podcast, news and commentary from Gun Owners Action League, your leading voice for the Massachusetts gun owner.
I'm Jeff. Across the table is Garrett.
What's up, man?
How goes the battle?
You know, we're getting through it.
Slowly but surely.
That's right. Birdie season's coming up. We're going to Jackman in a few weeks.
I'm excited to go.
Yeah.
You, sir, have a new hunting implement on the way.
I couldn't help myself. I'm like, I need it for Jackman.
Yeah.
I had to buy
well, it's time. You needed a proper bird gun because you have shotguns, but everything's set up for, rifled barrels for deer season.
Exactly.
And you've been borrowing bird guns.
Yeah, I have from you
for the in the meanwhile.
Yeah.
Now you're making a commitment.
That's right.
Dedicated bird gun.
Get my own bird gun.
So what are you getting?
It's an over under. Oddly enough, I'm getting a Mossberg. What is it? Mossberg International Silver Reserve over under and 20 gauge.
Right on.
I don't own an over-under currently, so I figured let's expand the inventory a little bit. And then, I can go, oh, well, I need it for classes too, It's an investment.
It's a tax write-off.
It's an investment in my students' future.
It's a tax write-off to protect the portfolio.
Right. Really cool. Hoping that'll be in the next couple of days. We'll get it all patterned up before we head up north to see if we can do some damage to the grouse population.
You just got to find the birds.
Yeah, that's right. That's right. Hopefully the birdies will show up and we'll get it done. What's going on in your neck of the woods?
Hunting season's going officially on the boards as of last night.
Speaking of, yeah. So you went out. You've been doing Mondays and Saturdays. Is that about right?
Just Mondays. So the place that I have a partnership with, an agreement with to hunt on their property, we hunt on their off days. So when they make it available for us, and at this time of the year, it's their off days are Sunday, Monday, but we're not allowed to hunt Sundays, so we just hunt Mondays. And then later on in the year, when things kind of open up, then we'll hunt on Saturdays, hunt a few more evenings in the week. But
so you're on the boards.
Yeah, went out yesterday, sat and suffered through the rain and the weather.
Yeah, it was crappy out.
I got pretty good and soaked. Like hunted in the morning, and then took a nap in the truck, kind of middle of the day through the worst of the rain, and then got back out for the evening. And then of course it started pouring again.
Yeah.
John was out for the afternoon. Him and I both got pretty good and chilled and soaked. John got an arrow off at a deer, and I think he just had a clean miss.
Yep.
And then with 10 past 6, had a buck walk out, and I'd kind of joked to myself that, if there's any sort of karmic justice, like, listen, I've sat all day, cold, wet, all I'm asking for is a shot, man. It's like, even a turkey. Like I got a turkey tag to fill too, so I'll even take a bird.
Just anything.
And then, buck walked out, and I just said, you know what?
It's time.
I'm not turning it down. So he stepped to about 25 yards and sent an arrow through him to both lungs. I think he made it not even 50 yards.
Went down.
I was joking with you since you like to tease me a bunch. He ran and tried to run up a hill, and then laid down about halfway up the hill. So all I had to do was slide him down the wet grass to my truck to load him up.
Just with one pinky, you just kind of go, okay, come on.
But I got to say, John is the consummate gentleman that he is. Texted me, and he's like, "Yep, I'll be right over," and helped me load him in the truck. We took him to the part of the property, did the field dressing.
What
John
a guy!
Helped,
Nice.
Loaded him back in the truck, and
off you go.
Off we go. So I owe him help with the deer recovery, and I'm sincerely hoping we got a couple really, really nice bucks that I think he'd be very excited to put down.
See him on the camera and stuff.
I am very much looking forward to helping lift one of those big ones into the back of John's truck.
Yeah,
so
there you go. So is it mountable, or is it just freezer food?
No. This is for food.
Yeah, there you go.
Part of our arrangement is just putting hunting pressure on the population. So it's kind of
that's why you're doing what you're doing.
The selective pressure off of me. It's everything's kind of, if it's brown, it's down category. So as far as I'm concerned, like the old saying goes, you don't pass up on a first day, which you'd be happy to have on the last day.
There you go. That's right.
All things considered, like I said, he walked out broadsided at 25 yards and
no regrets. No regrets. Doesn't have to be a trophy.
On his way to becoming something for the freezer.
There you go. Congratulations.
But in the meanwhile,
yeah.
So before we get into today's episode, we're talking to Dan Hagan, some great updates on some casework.
Fabulous. Yeah. Looking forward to that.
Goal alert, stuff on a state and federal level. But before we get to all that, since we're talking about hunting, I wanted to send a happy birthday to Mr. Ron Jetty of Jetty's Chop Shop, who's processing my deer tomorrow morning. He just passed 71 years old, and he's still just trucking it.
Still cutting them up, and nice. Very good.
So yeah, I dropped my deer off to him this morning, and he's like, yeah, just drop it off and I'll take care of it tomorrow. Cause he was going out hunting. He should be out hunting in the field right now.
Nice.
So
very nice.
Congratulations. Happy birthday to Ron, and congratulations to a young fella I met while I was there, Casey. Got a buck this morning and I helped drag it into the shop and everything. He was
nice.
Supposed to be,
he was checking in.
He was checking in.
Nice.
Said he was supposed to be studying for an exam for something. Oh, and he decided, he's like, maybe I'll go out and hunt for a couple hours in the morning. And he said he was in his stand for maybe 10 minutes and a buck walked out, shot him. So
there you go. Get back to studying.
Congratulations to him as well.
Congratulations. That's really cool. Really cool. All right. To business. First up, before we get to Dan and the rest of the stuff, first up, we do have a goal alert. I want to make everybody aware that next Friday, October the 31st, Halloween, as it happens, I'm sure that's, totally not on purpose. The Joint Committee on Public Safety and Homeland Security of the state legislature is going to be holding a hearing on 59 Second Amendment related bills. This is going to be happening at the Gardner Auditorium starting at 11:30 a.m. As we know, under the rules of the Massachusetts legislature, all bills that are filed by, a certain deadline, which happens near the beginning of a legislative session, as long as they're filed by that date, they're guaranteed a hearing, no matter how many sponsors they have, no matter how stupid they are, and nothing. As long as they're filed by that date, they're guaranteed a hearing. So the legislature, what they tend to do is they'll gather up a bunch of these bills by topic. In this case, it's guns, right? Second Amendment stuff. They'll pile them all together, and then they'll schedule one hearing to talk about them all. And in this case, this is happening next Friday, Halloween, October the 31st.
At the Gardner Auditorium. So, yeah. So they never talk about all 59 bills. They just pay lip service to a few of the highlights, whatever people are complaining about, and then they'll do what they were going to do no matter what, whether or not. It's amazing how all the firearms ones are always on holidays, right after holidays.
Yeah.
They're always on days where the availability for people to go is probably going to be limited.
Yeah.
And then all of a sudden, that's when we're going to hear all the gun bills.
Yeah, right. We're going to do the gun bills there. Yeah.
So we're going to get a fair shake at the table, of course.
So to follow what's going to happen, go to malegislature.gov/events/hearings/detail /5440, or just look at the Mass Legislature website on the upcoming hearings to participate. Please, contact your legislators. In the meantime, you got a week. Contact your legislators. Let them know that all of this stuff is nonsense, that you're strongly against Chapter 135 and all of the baloney that they're hearing next Friday. Let's stay engaged. Stay engaged and let's get it done. All right. Joining us tonight, we have a special guest, Dan Hagan, Esquire, 2A attorney extraordinaire. Thanks for joining us, man. I know this was a last-minute request. We appreciate you taking the time to come and talk to us about a couple of late-breaking things. How's it going?
Well, I'm doing well, guys. Thank you for having me. I really appreciate it. And finally, we have some good news here in the Bay State to report.
Yes, we do. Why don't you kick it off?
Sure. So today, the breaking news is that Kyle Culotta, who was previously held as a dangerous person in Massachusetts and denied bail, the right to post any bail, Elon Musk couldn't have got him out as of yesterday. But today, we were able to get the dangerousness finding done. The dangerousness finding was ended, and ultimately, bail was set in his case of $10,000. So the minute he has the $10,000 together, he's coming out.
That's fabulous. So he's been in there since June the 24th, coming up on 120 days, right?
That's correct. The good thing is the only conditions he has is, of course, he can't commit another crime while out on bail, but that's all of us have that condition.
Yeah.
But he also just can't possess firearms. Other than that, he's not on a GPS. He has no other conditions restraining his liberty once he posts that 10,000.
Well, good news for him. So I know that he has like a donation site going up, and people have been donating to it to help support his bail. So give us a little background. You're the lead attorney on this case. You got other folks working on this. What's the structure look like?
Yeah, sure. So it's really a team effort. There's no lead or anything like that. I mean, it's myself, Attorney Dan Kelly, who's an excellent attorney. He's one of the best attorneys in the state. As well as Kyle D'Souza, who's a young lawyer, but very sharp lawyer, and he's great at research and writing, and he's put a lot of effort into this. So this is, these things take a team approach because, I mean, we've been in the Mass Supreme Court and we're battling on the appellate level as well as in the trial courts, trying to get him bail. And so, again, it's all teamwork here.
Excellent. So, a little bit further background. I'm sure everybody listening knows about this, but Kyle Culotta was in his partner, his significant other, came in from Arizona, and you joined us a few episodes ago to go into deep detail with this. But essentially speaking, he came here with his significant other. They got pulled over for, what was it, a paperwork something or other, registration or something like that.
Yeah. Originally, they had failed to yield. So they were working at the time doing DoorDash, and they originally, the police claimed that they failed to yield at a sign, and ultimately the police believed that the insurance on the car was inactive, and so therefore they went to tow the car, did an inventory search, and as a result of that, found firearms. But it's important to point out it wasn't just firearms; it was basically all of his worldly possessions as they were relocating, and so. And they had just been in the state, as they tell the police, for just over a day. I mean, it was like 30 hours or something like that. But they had just arrived here and fell into the trap that is laid for all out-of-staters who find themselves in Massachusetts with firearms.
Welcome to the Bay State. Jesus.
I wonder what his relocation plans are now.
Yeah, right. So they hook him up, they jug him. And then he goes up before a judge and they say, well, you're a known bad guy with ties to the criminal organization known as Arizona. So we're going to throw you in jail and let you rot there for 4 or 5 months.
That's right. And that is the tragic thing about Massachusetts. So here you have someone like Kyle, who's a decorated veteran, 51 years on this earth, never committed a crime, was cooperative with the police, did all the right things. And the way Massachusetts rewards that is by declaring you a dangerous person and holding you without right to bail. And the problem with our law is the legislature passed the dangerousness statute with the provision that is an enumerated, one of the crimes that can trigger it is the simple possession of a firearm without a license. And that is enough in and of itself to trigger them to be able to request you be held dangerous. Now there should, and we argue there should be some plus factors. Should be something more than just that you were charged with that crime. Otherwise, why do we have a dangerousness hearing? Why even have a hearing? Because everyone's going to be charged with the crime. So if everyone who's charged is then held dangerous, we could do away with hearings. So we are arguing there has to be. Yeah, exactly. No, seriously. So we're saying there has to be something more. And, that's what we're battling in the appellate courts now about. And maybe ultimately the federal courts down the road as this thing unfolds more.
Wow, right on. So the immediate goal was to get Kyle out of jail, right? Get the guy out of jail so he can, try to start putting his life back together, at least before he goes to trial. But then there's the longer term goal of getting this whole nonsense kind of reversed and thrown out. And, because this is, like you said, this is crazy. It's a paperwork violation that's, perfectly legal in most of the other states. You cross into Massachusetts and now suddenly you're a dangerous felon, just automatically. That's
correct. It is a trap for folks that come in from out of state. And, what he's charged with are crimes that carry mandatory minimum jail time, which means that by statute, you have to, if you are convicted of that crime, you must go to jail for the mandatory period. So even a judge can't let him out of that. So that's why this is, the stakes are still high. Obviously, as you said, the first and most important hurdle was to get him out on bail and to get him home. But that doesn't end the case by any means. The fight really, and that just is beginning, because now you have to deal with the case in chief, which, is the whole fight. So, we're working on that. And Kyle does have, there's several exemptions in the law that could apply to his conduct. He has defenses. I don't think he committed a crime. There's some special things I've been working with, actually, and I mentioned it briefly on the podcast, I think the last time I was on, but actually some potential bright lines with Chapter 135 that may benefit Kyle. So we're working all the angles, and we're going to stay on it and try to get all of this resolved favorably for Kyle.
Right on. Well,
so what are you guys thinking about for a timeline as far as, okay, bail has been set. Presumably he'll make that at some point in the near future. But what is he looking at as far as time to a trial, and then what are the possible consequences he could be facing?
Sure. So, his next hearing is in December. I would anticipate, if this were to be a trial, it would be sometime in, the springtime, early summer, something like that next year, if it gets all the way to that point. And obviously the stakes, like I said, are high because he's facing, mandatory minimum jail time and felonies should he be convicted. And that means how mandatory minimums work in the state of Massachusetts is that you need to serve every single day of that. There is no credit for good time. So, in the federal system, when you get a mandatory, you still get a deduction for good time. In Massachusetts, if you get a mandatory sentence, it is every single day of that sentence. So the stakes are high, but we're working on it. And again, he has defenses. And so I'm hoping that with some of the things that we're planning, that the district attorney's office sort of sees the light, and this case gets a lot better for Kyle, in the coming months.
Mm-hmm. Does the time he's already served in jail apply towards whatever possible consequences could come?
Yes, it does. It does. It doesn't. That's not dead time. So anything that he, say he were to ultimately go all the way and get convicted, which I don't believe will happen. But if that were to be the case, any time he gets, the time he's already served would be deducted from that.
Wow. Like you said, not out of the woods yet, but what an important first step.
It's a milestone, right?
Milestone.
Yeah.
Is at least now, he can, he can be out, he can, be with his family, work with his, attorneys much more freely to build a defense and get all the information together. And there's some truth to perception. Him being able to walk into court in a suit is certainly going to look different for him than walking in a prison jumpsuit. So it's absolutely fantastic work. It's hugely beneficial for him, and I'm sure he appreciates it quite a bit.
Absolutely. Kyle is a great guy. I represent a lot of people, and I will say, and I said this to the judge, like, of all the people I represent, Kyle's one of the least dangerous people I've encountered. I mean, he's just a very nice guy, very respectful guy. He's very thankful for all of you and all the supporters out here who have been talking about his cause and keeping his name in the news. And so, he is a great guy, and I'm just happy because remember, we also got the most serious charges dismissed. So all the high capacity stuff, that is all gone now. Yeah. So that's what would expose him to state prison time. I mean, even more serious, indicting him. So we were able to get that off the table. So, we're moving things in the right direction, and I hope we keep going that way. And ultimately, I think it would be a good outcome for Kyle.
Well, fabulous work to you and the other attorneys on this case. Great stuff. A long way to go, but still fabulous work so far.
Yes, thank you, guys.
The other thing that we wanted to talk to you about, the other piece of good news for today, we're going to get Dan Hagan on here to brag a little bit. So let's talk about Commonwealth v. Santana-Rodriguez. So a little bit of background. This is the self-defense case, right? Give us the background on that one.
Yes. So I also think I had mentioned this briefly on the Gold podcast previously, but I have a client who was at a nail salon in the Holyoke Mall getting a pedicure with a female acquaintance when a known criminal came into the nail salon who was the ex-boyfriend of the female acquaintance of my client. And not just by my client's account, but by other witness accounts, began assaulting my client, hitting him, while my client's back was against the wall. Ultimately, the guy pulls his shirt up and exposes a firearm to my client and says, what's about to happen. And at that point, my client pulled out his firearm and fired. The problem is, given how everyone was situated with the two kind of in close proximity to each other, close quarters, he ultimately shot and hit the wrong person. He shot twice and hit the nail technician once. And the nail technician, unfortunately and tragically, passed away. But my client had an LTC. He was legitimately defending himself against a threat to his life. He had seconds to act. It was a tragic incident that occurred. But he called the police right away. He stayed for the police. He tried to render first aid. I mean, he did everything he could under the circumstances. And so what this caused was a question that had never been decided in Massachusetts, which is, can I get up in front of a jury and argue that he was defending himself against his attacker when the person who dies is not your attacker? And that had never been decided in Massachusetts until a few days ago.
So we had you running up to the SJC. What was it, 2 months ago now?
It was actually in June. They took it
that long ago.
Yeah. They had a special session for us in June to hear the case, and I thought the arguments went well for us. So we were hoping for a good outcome, but you never know.
Yeah.
You never know. You never know with these things, because they could, just as easily, because the argument goes well, they can go back and make a decision that's not so good. So we're very happy. And basically how they decided it was, if it's an accident. So if you are truly defending yourself, and that's what people have to understand, because I think people who misread the decision or don't really understand all the details think that this is somehow a license to have things be like a Wild West type situation. But the reality is the jury has to first find that you are actually defending yourself.
Right. And
once the jury finds that, basically murder then comes off the table. And the question then is, was it simply an accident, or were you reckless in some way? Were you beyond just a mere accident? Did you go further than that and do something that really endangered other human life? And in that case, it could be potentially an involuntary manslaughter, but it will not be murder now in the Commonwealth if you make a mistake simply by trying to defend your life.
It kind of gobsmacks me a little bit that they even tried to bag the guy with a murder charge based on this, but I guess, Massachusetts, right? So this individual has he been in jail this whole time?
He has. I mean, he's charged with first-degree murder. So first-degree murder, there's presumptively no bail. So you are held without right to bail on things like that. And remember, the government was arguing in this case that it still should be murder, that if there was any sort of carelessness, any sort of negligence, which, I mean, in every case, look, you hit the wrong person. I get, there's going to be some argument that you were careless. They wanted that to still be a murder. And so that would really make it so there wouldn't be much of a defense there.
Yeah.
So we were very thankful that that's not how the court decided the issue and said, no, murder's off the table.
Yeah. If they had not, so what you're saying basically is if they had decided the other way, if they had not permitted that defense, then the guy, I mean, it would have been really hard to navigate the waters going forward for the guy.
Well, yeah, if they didn't recognize the defense at all, I'm not sure, we would certainly limit what we could say. I mean, because there's no question he shot the wrong person. So, I mean,
the facts of the case are, yeah.
Right. So, the certainly limits our ability to argue, a serious defense for him.
Well, great news, man. Good stuff. 2 wins back to back. Beautiful.
Back to back. Slowly chipping things, chipping away at our rights here, trying to get some things back. And I do think this, I was just going to say that I do think that this gun owners should also think about the self-defense ruling, I think very positively for another reason. And that's that, the scenario where, and I know a lot of people are critical of sort of you hit the wrong person and, and I get that because look, it is a tragedy and it's very tragic this person passed away and nobody wants that. And clearly this was an innocent bystander. But, there's other scenarios where this could apply. And one of the most, I think, interesting is, and I discussed this with the Mass Supreme Court during our oral argument, is what if it went through your attacker and killed somebody else? I think that's something that could happen to anyone, even if you were practicing perfect self-defense, you hit your target, you do everything right, and, the bullet finds its way to an innocent party. And and before the other day, there was no defense built into Massachusetts law for that.
Yeah, I hadn't thought about it that way. Obviously you did. Right on. Man. All right. Well, we don't want to keep you all night, but listen, we appreciate you coming on talking about this stuff. This is great. Great. 2 back-to-back wins for the Second Amendment community here in Massachusetts.
Absolutely. Anytime, guys. I'm happy to come on.
All right. You got anything?
Nope.
All right.
I think you're overdue for a well-deserved celebration.
There you go. There you go.
That's it. We're a party.
Pour a couple of fingers, hang out by the pack deck. Man,
That's right. That's
right on. All right. Attorney Dan Hagan, thank you for jumping in. We just wanted to take you for a few minutes to go over the good stuff, and we'll certainly invite you back at some point in the not too distant future.
Absolutely, guys. Sounds good.
All right. Thanks a lot.
Thanks, Dan.
Enjoy the night.
Yes, thank you.
It's nice to finally have some good news coming out of court decisions, coming out of Massachusetts.
Dude, seriously.
And it's like, like you said, not out of the woods yet, but it's an important step in the right direction.
It's a big, in a long race is going to have a lot of hurdles. It's a big first one that came down in his favor, and that's great. That's good. That's good. It'd be good to see the guy out of jail. He should never have been rotting in there for 5 months. It's ridiculous.
Shouldn't have even been arrested. But anyway.
Yeah. Anyway.
There's a reason I'm not going to be on that jury.
That's right. What are we doing here? Not guilty.
Staying local in the state of Massachusetts. So it's been out for a little while, but the other stuff has happened in the interim. But the final report is available on the Emergent Firearms Technology Commission.
Oh, yes. So, we've covered this a couple of times.
Yeah, the Mass Commission on Emerging Firearms Technology wrapped up its report looking at so-called smart gun technologies and firearms microstamping. And while it's being framed as progress in gun safety, especially by the person who is going to be enriched by it, the real story is, of course, more complicated. So, talking about in the scope of microstamping, the commission says marking shell casings with a microscopic code could help police trace guns used in crimes. On paper, that sounds somewhat reasonable, but in practice, it doesn't quite work.
Sure.
The technology, first of all, can wear. It's easily tampered with, and no state in the country has actually made it work at any sort of scale. California, New York, New Jersey, they've all been trying for years, and none of them have a functional system yet.
Because it's nonsense.
And critics worry this could end up being another expensive mandate that burdens lawful gun owners and manufacturers without actually stopping crime, which is true.
Absolutely true. And this is a feature of it, not a bug. That's what they're going for.
Then, of course, there's the personalized firearms, or the, put the bunny quotes around smart guns.
Smart guns.
Those use fingerprints or facial recognition, some sort of biometric interlock to fire only for authorized users. The commission admitted that only one company, BioFire, is even producing them and roughly 4 times the cost of traditional firearms. The group stopped short of recommending a mandate, instead suggesting short-term tax breaks to encourage voluntary adoption. Still, many in the firearms community see the risk. Once a technology like this exists, politicians tend to move from optional to required because, who wouldn't want it to be more safe?
Yeah. Anything, right? Anything that's not illegal is mandatory. Yeah. So the commission has published their findings, recommended microstamping, or endorsed it anyway. And they're endorsing, but not recommending the personalized BioFire stuff.
So the broader takeaway is the commission is recommending more study, more bureaucracy, and a cautious move.
Go figure.
Towards the kind of technology that Second Amendment advocates that we have been warning about for quite a while. Technologies that have some sort of, theoretical, sweet-sounding stuff to the gun control crowd, but often turn into just backdoor restrictions on lawful gun ownership.
Yeah.
So the report is wrapping itself in the language of safety and innovation, but for us, the message is clear: stay alert, stay informed, and make sure that the so-called modernization doesn't quietly chip away at constitutional rights. So they're, saying they've essentially spent all the time and money to say, yes, we should continue looking into this.
Yeah. We have top men working on it. Top men. Glock is shaking things up this week. Holy cow. So I know that there's more background, but basically speaking, they passed a law banning most Glock models in California that was just signed into law by Gavin Newsom a couple weeks ago. Now, whether or not this is in response to that, we'll get into that in a minute. But as far as timeline goes, he signs the law in last week, and this week, Glock announces that they are discontinuing virtually all of their current lineup of pistols.
Well, as of this recording, so there's some back and forth of, questions about what exactly where the line stops from speculation to reality. But a social media post from Glock Store, which is not Glock Inc. or Glock the company that most people think. This is a somewhat affiliated business, but they posted to their social media that Glock will be discontinuing the manufacturer shipping of most current pistol models after November 30th, keeping only the Glock 43, 43X, and 48X from its current lineup. Discontinued models are reportedly being replaced by a new Glock they call the V series, redesigned specifically to prevent the installation of illegal switches. So they will no longer be producing like the Generation 4s and 5 Glock 19. It'll be the Glock 19V. Or the 17's going away, and it'll now be the 17V. Now, a switch, if you haven't seen it in the news, is a small device often manufactured in China and trafficked into the United States that disables key safety components in the pistol's action and converts the semi-auto pistol to full auto.
Right. Illegally.
States like California have publicly blamed Glock for the problem, even though Glock has never made, manufactured, or sold
or endorsed switches, or anything else.
Under federal law, the switch itself is treated as a machine gun per the National Firearms Act, per the Gun Control Act. So mere possession of one of these Glock switches is treated the same in the eyes of law as possessing a fully operational machine gun. The argument California makes against Glock is that these foreign-made devices that are illegally imported and sold on the black market, it is Glock's position as the manufacturer to take fault and take the blame because they should be the ones doing more to stop international trafficking.
Which is nonsense. Nonsense. So Glock's statement frames the change as a business decision. So their official statement on the matter says, quote, to focus on products that will drive future innovation and growth, we're reducing our current commercial portfolio. This streamlined approach allows us to concentrate on continuing to deliver the highest quality and most relevant solutions for the market.
He sounds so excited.
That is so marketing management.
Yeah.
You know, it's a lot of words. It's a lot of words. It says absolutely nothing, really. Sources say that the new V series is not going to be offered in the Optics Ready MOS version. So you're just getting the base models of the Vs to begin with, and then we'll see. So people are like moderately pissed about this.
Yeah, critics are kind of furious, and they're claiming that Glock is bowing to pressure from gun control advocates. Now, that perception, like you said, has grown given the timing just after California Governor Gavin Newsom signed a new state law banning the sale of all Glock and Glock-style pistols.
That's a lot of pistols.
Still, I mean, Glock's global sales make it unlikely that California alone could seriously, jeopardize the company's financial status, especially considering the state has already restricted new handgun models since 2013, and most Glock pistols were already missing from the approved roster that California puts out. The new law, meanwhile, is being challenged by California Rifle and Pistol Association, along with National Rifle Association, Firearms Policy Coalition, Second Amendment Foundation.
So I don't necessarily think that they're doing it from entirely a market perspective. Like they can, and I have no special, insight into this, but they can do this as a response to what California did without it being for fear of their market share, right? They're not afraid of California as far as market share. Like you said, you're absolutely right. Okay. But other states, you're going to see the writing on the wall. California is not the only anti-gun state in the union. So between that, agencies, what they might be seeing is that first domino starting to tip over. And so they're getting out in front of it and saying, hey, we have a new model. We have a new thing that just nips this whole thing in the bud. You could argue that SIG could have taken this tack months ago, if you want to draw the connection there.
Yeah, totally understandable. And there are people that have said, listen, it's not just California. It's all the other states that deal in the realm of handgun rosters and what's approved and what's not approved. And they're also standing, dealing with lawsuits from dozens of different entities based on what's essentially a foreign criminal enterprise illegally importing machine guns into the United States.
Yeah, right. Well, we don't worry about that. What we worry about is, we worry about the manufacturers.
So, there is some validity to the idea that Glock may have to make some sort of pivot, some sort of move as far as what would mitigate a lot of that liability or legal liability. But others, there are the critics, but others are watching with somewhat curious eyes. So, Glock famously reshaped the modern pistol landscape with the Glock 17 in 1986. And for roughly 4 decades, the company has iterated on the same basic design, just different sizes and different chamberings. So the question will be is the V series a small, defensive tweak, a marketing pivot to deal with the issues that they're dealing with? Or is this going to be a genuine change in their firearms? So, are we talking cosmetic changes like finger grooves versus no finger grooves? The past generational updates?
Yeah.
Or will this become Glock's version of the Smith & Wesson, internal lock, AKA the Hillary hole?
Yeah, the political change.
Or are they bringing something more substantial to the table that actually improves on a proven platform? So that we're not going to know until the new firearms hit the market and we actually see what the changes are going to be.
Yeah, no, I'll reserve judgment as far as that goes. It's hard to, you and I tease each other about guns all the times, but the bottom line is Glock has a fabulous platform. That's why everybody copies it, right? That's why it's almost so ubiquitous. It's hard for me to imagine what they would do to improve on that. But if they are making some kind of substantial technological leap, like you said, I'd be really interested in seeing what that is.
Yeah. And I mean, one of the criticisms, and I think this is absolutely fair, is there's such a huge aftermarket industry.
Oh God. Yeah.
For
like
what they say are called
J.C. Whitney
pistols.
of the gun world. Yeah.
Everything from strikers to sears, different triggers, trigger bars. I mean,
every
basically
single part of 34 or whatever the hell it is parts of the gun have a whole aftermarket
exactly
behind
whole industries built around this, and there are companies that survive based on selling aftermarket Glock compatible parts. Yeah. So I'm sure for a lot of them, it's very concerning to be like, okay, well, what are these changes, and can we still function as a business? Obviously, they're going to have to pivot something. So
they're going to have to. You know what? Maybe they're updating the sites finally.
So there are ripples. We're going to see what happens.
We'll see what happens. National stuff. Before we get into the Supreme Court, there are whispers that the ongoing government shutdown is resulting in NFA registrations, applications to come to a grinding halt. So NICS is still going on. The FBI still has that going, but the ATF has apparently essentially closed down registrations, NFA registrations, tax stamps, etc.
Yeah, I think they're arguing that it's not necessary. It's not in the essential services or the essential core functions.
Of course they are. The Bureau of Alcohol, Tobacco, and Firearms is not doing firearm stuff because it's not essential. Yeah,
but obviously, folks, they're gonna stake their claim that because these NFA items require registration, because of the process, and because of the way they've been historically treated, that these things are not necessarily protected by the Second Amendment the way everything else is.
Right,
so
right.
I'm sure there's going to be some argument to that effect made as to how they're going to handle delays in the NFA registration process.
And what's going to happen when the government opens up again, right? I mean, it's not just like it's not. It's emblematic of the wider issue. It's not just NFA stuff, but when the government reopens again, people are going to start lining up at the window. And that's a long line.
Of course, there's going to be some backlog to go through, but it also speaks to the legislation, some legislation that has been thrown around, talked about of retooling and recalibrating the National Firearms Act, because the registration process, it's been long discussed that there is no federal firearms registry.
Right. Well, yeah, right.
With the NFA,
supposedly.
Supposedly. With the NFA, it was really just a matter of a tax collection process.
Yeah.
So they're keeping records to make sure that people have paid their taxes on the thing. Now that the tax has been removed, people are questioning, well, then what is the purpose of this process if it's no longer keeping tabs on who's paid the tax and who's not paid the tax?
Yeah. Just so.
But then the question will be,
so that's the argument.
Which legislators on a federal level are going to or would be willing to expend the political capital to start chipping away at the National Firearms Act? I think specifically suppressors would probably be the first.
Yeah. Not that would affect us here in Massachusetts.
But then talking about, short barrel rifles, short barrel shotguns, and what that whole thing is going to look like. Should the NFA be, started to be broken up and pieced out?
Yeah. Well, keep an eye on it. So in other breaking news, the Supreme Court has, surprising everybody, accepted another Second Amendment case. Now, last episode, we talked about Wolford, the Hawaii case.
Yeah, Hawaii's vampire rule.
Yeah, the vampire rule. And after, splitting out and tossing out, denying cert to something like 60 other cases, earlier this week or last week, they granted certiorari in U.S. v. Hamani.
Yeah, no, interestingly, we talked about Snope. We talked about some of the other cases that went on and were dragged and rescheduled and ultimately denied. And then Kavanaugh writing his thing that maybe they'll talk about it in a year or two. But now here we have a couple of cases that have been granted certiorari. So
we had nothing for 10 years, and then we had Bruin, and it's like a trickle. And now we have two in the same month.
Well, which makes sense because a lot of the stuff they're dealing with now is people's responses to Bruin. But like you said, we talked last episode about the case of Wolford v. Lopez. That's Hawaii's vampire rule that bans the possession and carry of firearms on all private property, even those typically open to the public, unless the property owner expressly and conspicuously posts approval that the carrying of firearms is allowed on the premises.
Yeah, that was that presumptive denial thing. Yeah.
So that's the one case that's already been accepted. But as of Monday, October 20th, the court has granted cert in a second firearms case, this being United States v. Hamani. Now, this one is interesting and slightly different because the writ of certiorari was filed by the government, not typically what we think of as the petitioner.
Right.
And at its heart lies a question. Can the government bar habitual drug users from owning firearms without violating the Second Amendment?
So the combatants go to their corners. In the first corner, we have the United States of America. The government's position, written by their Solicitor General, is arguing that 18 U.S.C. 922 G3, that's the law that bans gun possession by anybody who's a, quote, unlawful user of controlled substances, fits squarely within America's historical tradition of firearms regulation. So the federal government is arguing that people who use pot should continue to not be allowed to purchase and possess firearms. All right. Their reasoning goes a little bit like this. At the founding, legislatures restricted drunkards and dangerous individuals from carrying arms or even living freely in society. Today's law, they say, is just a modern reflection of that same idea. Temporary disarmament of people who pose heightened risks while under the influence. And unlike a lifetime ban, 922 G3 is self-lifting. You stop using illegal drugs, and the restriction disappears. So the government paints Hamani not as an ordinary citizen that's been unfairly targeted, but as a habitual user and a dealer. Somebody who admitted to smoking pot every other day and also kept a Glock and drugs in his home. And they're telling this is about public safety, not overreach. Drugs and guns are a dangerous combination, they say, as Justice Alito once put it. They also stress that this isn't a rogue policy. Over 30 states and territories have similar laws on their books. So in the government's view, the Fifth Circuit, which struck down the law as applied to Hamani, broke from history, from precedent, and from common sense. They warn that if this ruling stands, it'll wipe out prosecutions nationwide under a law that's been central to federal gun regulation for decades. So, in the other corner.
So, the brief in opposition So this is Hamani's lawyers. They responded with a completely different frame. They say that this case is about, one man, not a national constitutional crisis. Their brief is focused and somewhat sharp. They accuse the government of inflating the record of Hamani, dragging in inflammatory allegations about terrorist sympathies, with Iran, and
if you read the headlines,
that was never part of the actual indictment.
If you read the headlines, almost invariably the word terrorist comes up either in the headline or the byline, or just below.
Yeah. So this guy in particular, some of the framework is saying that this is really just about marijuana, but he was also a user of cocaine, sold drug, like he was a drug dealer. And the stuff about terrorism, I guess he got stopped at a port of entry and had materials on his phone of
questionable nature
and where his sympathies really lie. Stuff about Qasem Soleimani and let's put it this way. Hamani is probably about the least sympathetic person that could have been walked up for this case. But the question that his lawyers are saying is that whether Hamani, who used marijuana but was not intoxicated when found with a firearm, could be constitutionally charged under this statute. And their argument follows the Fifth Circuit's reasoning in United States v. Connolly that the Second Amendment allows disarmament only when there's a clear historical basis, like laws disarming people who are dangerous while intoxicated or actively threatening harm. But no founding era analog ever disarmed someone merely for being a user of a substance, especially not on an ongoing indefinite basis. So yes, you cannot carry when you're drunk, but if I was drunk yesterday, it doesn't mean I can't carry today.
Right. Like if I got drunk yesterday and it's not in my system anymore, I can go drive a car tonight and that's okay.
Right. So his team also pushed back against the government's kind of fallback argument that people can seek relief under 925C, which is a procedure that was once meant to restore firearms rights. We talked about it on a previous episode of getting your rights back for that kind of stuff. And how that has been returned to the Department of Justice, that authority.
And also why we argue that it shouldn't have to even be that way.
But Hamani's lawyers point out that Congress basically defunded that process for over 3 decades, making it effectively a dead letter until this spring. When that power was returned to the Department of Justice. So to rely on that now, they say, is to build a bridge on air. And they dispute the government's claim of a circuit split. The Fifth Circuit, they argue, didn't strike down the statute on its face. They only struck it down as applied to Hamani himself. No other circuit, they say, has held otherwise in a comparable situation after the Supreme Court's Bruin and Rahimi decisions. So they say that there's no real conflict and no reason for the Supreme Court to intervene. Their bottom line is this is not the case to make new Second Amendment decisions.
The government says, yes, it is. In its reply brief, the government doubles down, framing Hamani's case as the perfect vehicle for review. They argue that the Fifth Circuit's logic essentially nullifies the statute. Under its rule, no one can be prosecuted unless they were actually high or intoxicated at the moment that they possessed a firearm. That, the government says, defies history and precedent because both law and logic recognize that habitual drug use creates an ongoing danger, not just a danger in the moment. So they also point to a deepening split. The Eighth Circuit has upheld the law in cases like U.S. v. Cooper and Baxter, while the Fifth Circuit has struck it down. And just weeks before the reply was filed, the Third Circuit added yet another layer, with United States v. Harris disagreeing with the Fifth Circuit's narrow view. In short, the government says, the circuits are colliding, and the Supreme Court can't sit this out. Finally, they highlight a new development. The Justice Department has proposed regulations to revive and clarify the 925C relief process that we talked about, allowing limited case-by-case restorations of rights, but keeping habitual drug users, quote, presumptively ineligible. That, they say, shows the system already has a safety valve. Courts don't need to invent one through constitutional carve-outs. They say we can take the rights away, and there is a process by which you can fight and spend your money and your time and your effort to get them back. Therefore, it's cool. Not hard to imagine what I think about that.
Yeah.
But
so
anyway,
the two pressing questions that the Supreme Court is probably going to have to face is, the government wants the court to say that habitual drug users can be disarmed, consistent with the nation's longstanding tradition of keeping arms from dangerous persons. Amani's side says that there's no historical precedent for a sweeping indefinite ban, and that constitutional rights can't hinge on vague labels like, a user or an addict.
Yeah.
So, personally, I would not be surprised if the Supreme Court upholds the law that bars habitual or addicted illicit drug users from possessing firearms. So, it's kind of important to keep in mind. It's framed around cannabis, but this case isn't just about cannabis. It would cover all controlled substances.
Yeah.
So now there's definitely some weight to the argument that terms like addict or habitual user are too vague.
Yeah.
Like, what is a habit for one?
What does that mean?
Is a
what does
occasional
that mean?
thing for someone else.
Right. If I use it once every 2 years, but I do that regularly for 20 years, is that a habit?
Well, if I smoke 1 cigarette a day versus 2 packs a day, what?
Right. What degree is the, yeah.
Exactly. So, but throughout American history, there's always been a line between bearing arms and doing so while under the influence. Like historically, you would not be allowed to carry a gun while intoxicated, while drunk. And I expect the government to argue that someone addicted to methamphetamines or opioids poses a comparable risk.
Yeah,
so someone
of course
going
they're going to
through
frame it that way. Yeah,
someone going through withdrawal or is pursuing their next high isn't in a stable or safe frame of mind, no more than someone who had like a few too many Bud Lights at the bar. So even under the Bruin framework of text, history, and tradition, I don't know if this becomes a successful facial challenge of the law, to say that the law has no legal implications or no legal applications. So I think, the statute will probably survive, at least in broad strokes. That said, if the case were solely about, marijuana and cannabis, especially given how many states have legalized or decriminalized it, I think it's something like 40 out of the 50 states permit medical use. And another 24, almost half the country, allows for some level of recreational use. The outcome might look different, but that's not the question before the court. So what'll be interesting for me is to see how both sides frame their arguments, to see what questions the justices ask, what questions they don't ask, and importantly, how the court frames, what is the outcome? How do they frame the opinion? Do they go broad? Do they go narrow?
Yeah. So I agree in principle with you. I think that the way that things are shaping up, the statute is likely to survive. It seems to me, first off, that the government could cut this whole nonsense just in the bud by delisting marijuana and just taking it out of statute altogether. But that's a different argument. This is the specifics in this case center around marijuana, but the government in, defending their position is going to frame it in the worst possible possible framework.
They're going to show the picture of Portland.
Right.
And saying, should all of these people now be given guns?
Right. They're going to say, the meth head, the fentanyl, addictions and so forth. So yes, it's, I think personally that I would like to see pot delisted. It's just stupid, but be that as it may, I think that it's likely that the statute in some form is going to survive. However, it is interesting to me that they took this case over the other ones in the similar vein.
Yeah, there's about a half dozen other ones that people have petitioned and not been granted certiorari.
It comes to the way that, how do I frame this? Especially coming on the heels of Rahimi. Okay, so Rahimi, the argument becomes, do you place a restriction on somebody because of what they did or because of who they are? Okay, if you have committed a felony or, you're currently dangerous, like the whole Rahimi thing was about, then you can be denied your rights to possess firearms. If you have a felony somewhere in your past, especially a nonviolent felony somewhere in your past, right? Now you're enacting a restriction on somebody because of a status, not because of an action. Maybe they're going to link these two under that kind of a philosophical framework. If you have used pot in the past, it's kind of low-hanging fruit. The government's going to argue that you're a habitual user and therefore, you're ineligible to possess these rights. Kind of the way that I see it shaping up. I don't know, but I can see a faint but, kind of distinct line from Bruin to Rahimi to this.
What could possibly be this decision?
Yeah, and so we'll see. Yeah, interesting stuff. We'll see how this stuff develops. We got a couple of interesting shows coming up. We're getting into the holiday season, right? So things are developing. We're going to be going to shoot some birds in a little bit and get into deer season. But in the meantime, that's it for today. Thanks for listening in. If you haven't already, make sure to subscribe to the show, share it with friends. Check us out on Facebook at facebook.com/Goal Podcast MA, on YouTube at The Goal Podcast, or on Twitter at Goal Update.
To join Goal, visit goal.org and click the Join Renew button on the top of the homepage.
If you have a topic you think we should cover, if there's something going on in your club or your town, or if you have a question for the mailbag, shoot us an email at goalpodcast@goal.org.
The Goal Podcast is a production of Gun Owners Action League of Massachusetts. The views and opinions expressed are those of the hosts and guests and do not necessarily reflect those of Goal, its staff, or affiliates.